You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 5, Who to Share and Not Share Your Invention With, and Patent Application Deadlines. My name is Dr. Adam Diamond, founder and owner of Diamond Patent Law in Los Angeles, California, and I can be contacted at patentingforinventors.com. That's patenting, F-O-R, inventors.com, if you have any questions related to patenting or intellectual property in general. In this episode, I'm going to talk about something very important, and that's patent deadlines. And as I talked about in the last 2 episodes, you can't patent anything that was already known in the public. The exact patent rule says that you cannot patent anything that was described in a printed publication or in public use, on sale, or otherwise available to the public before you filed your application. So if you tell your friends about your invention, or you create a prototype of your invention that you show around, or you write about your invention before you file your patent application, then you can't get a patent on it, with some exceptions that I'll go over later in this episode. So who should you talk to your invention about? Ideally, you shouldn't talk to anyone about your invention unless that person has signed what is called a nondisclosure agreement, or you can tell an attorney. This doesn't mean that you can't tell your friends that you have a great idea for a new kind of avocado slicer, because avocado slicers already exist, so you're not telling them anything that isn't already known in the public. But what you want to avoid doing is telling them any of the details about how your new invention works, because once you start telling them the details about how your invention works, you're putting your invention in the public. Now, it's okay to tell an attorney about your invention because they're already under an ethical obligation not to divulge your invention to anyone else, or else they could be disbarred. So what is a non-disclosure agreement? It's just a simple contract by which one or more parties agree not to disclose confidential information that they have shared with each other. The people that you should have sign a non-disclosure agreement are people that will help you get your invention going, such as the manufacturer or someone who might want to license your product. You would also want to use a non-disclosure agreement if you want to hire an independent contractor to help you create or design a prototype of your product. One of the difficult areas for inventors to understand is that potential investors, like venture capitalists, generally will not sign non-disclosure agreements. There are lots of reasons why, but mostly it's because they just don't want to open themselves up to liability when they don't have to. Investors maybe pitch thousands of ideas, and one of those ideas may be pretty similar to your idea. And let's say the investor decides to invest with some other company that has that similar idea to yours. And you find out later that this competing company of yours used the same investor that you would talk to about your own idea. You might think that the investor stole your idea and told this other company, so then you decide to sue that investor. Investors just don't want to go through that hassle, so they don't sign them. So the problem is, how do you talk to an investor about your great idea if by telling them your great idea without a non-disclosure agreement, your invention might be available to the public, and now you can't get a patent on it anymore? Well, there are 2 things that you can do. One is that you file a patent application before you talk to an investor, and this is the safest thing to do. There are 2 main types of patent applications you can file. One's called a provisional application, and the other is called a non-provisional application. A provisional application is cheaper, but there are lots of things you have to be careful about if you file one, so you have to use these with caution. I'm going to go over the differences between provisional and non-provisional patent applications and their advantages and disadvantages in a later episode. The second thing you can do is a little more dangerous, but still a possibility, and I'd really only recommend it if the cat's already out of the bag and you already told a lot of people and your friends about it, and that is, in the United States, it's possible to still get a patent on your invention if you file your application within 12 months of publicly disclosing it. This is called a 12-month grace period. Let's say that you were at some product convention on January 1st, 2017, and you are showing your product so it's available to the public. You can file your application by January 1st, 2018, and your own disclosure cannot be used against you. This sounds great, but there are a few things we have to worry about. First is that it's only your own disclosure where you get the 12-month grace period. Let's say on February 1st, 2017, someone else comes up with the same invention on their own and publicly discloses it. That disclosure, even though it was shown just 1 month after yours, makes it so you can no longer get a patent even if you file within your own 12-month grace period. The 12-month grace period just applies to your own disclosures or disclosures made by people that got the invention from you, not anyone else's disclosures. So by not filing quickly, you're risking that someone else may come up with a similar idea, which could prevent you from getting a patent. The other problem with trying to use the 12-month grace period is that most countries do not have it. The US is one of the few countries that allows inventors to file a patent application 12 months after disclosing it. In most countries, once it's disclosed by anyone, even by a day, even if it's yourself, then you can no longer get a patent on it. It's considered in the public domain. There are some other countries that have a 12-month grace period. Some countries have a 6-month grace period. Some countries have a grace period, but only for specific situations that usually don't apply to the small inventor. So if you're interested at all in trying to get a patent in other countries besides the US, then you don't want to mess around with the grace period. You want to file as early as possible before you disclose to anyone. I'd only recommend looking at the 12-month grace period if it's already too late because you disclose your invention to people without getting them to sign a non-disclosure agreement. If that's the case, you want to note what date that is so you can calendar 12 months from that date as the deadline to file your patent application. There are all kinds of nitty-gritty details that I didn't get into with non-disclosure agreements, and details having to do with the grace period for filing an application, and details for what's considered a public disclosure, or a sale, or a public use. But the gist of it is, don't talk to people about your invention, don't disclose it, don't sell it, don't use it in public before you file a patent application. If you tell anyone, make sure that they've signed a non-disclosure agreement or your patent attorney. And if you've already talked to people about your invention, file an application as quickly as possible, but especially no later than 12 months, because after that, you legally can't file a patent application for your invention anymore. In the next episode, we're finally going to get into the patent application itself and start with a brief overview of all the parts of a patent. And in the episodes after that, I'm going to go into how to write each part of the application. Until next time, I'm Adam Diamond of Diamond Patent Law, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.